I see this all the time. Almost everybody wants to fight over the house in their divorce. They just don't realize that in most cases, they don't need to be or they shouldn't be. In this video, I'm going to talk about the three most common issues that I see as a divorce lawyer in my cases regarding people fighting over the marital home. The first is going to be the fact that they probably can't afford the house by themselves in the first place, even if they make enough to pay the mortgage payment. The second is going to be that most people don't understand that the court is going to require certain things of them if they're going to keep the house that they're not actually able to do. Finally, in some cases, the spouse says, "Hey, if I can't have it, you can't have it." And they decide just to burn the whole thing down. I'm going to tell you what to be on the lookout for and how to deal with it if that happens. Welcome to the channel, guys. I'm Sean Smallwood. I'm a divorce attorney in Orlando, Florida, and I make videos on this channel about divorce and family law issues with the hope of adding some positive value to your situation, which, if you're watching this video, you're probably going through a very tough time and need some encouragement, some hope, and some good information. So if you like this video, hit that thumbs up icon and consider subscribing to this channel. Okay, the first item that I'm going to talk about is the fact that in divorce, most people who are fighting tooth and nail to keep the house can't actually afford to keep the house if they were to get it. And that's because even if you make enough money to pay the mortgage payment after the divorce, there's certain things that you're going to have to do as part of equitable division, splitting assets in the case. The thing that a lot of people overlook and forget about is the fact that the other spouse is entitled to 50% of the equity in that home. So if you bought the house 5, 10 years ago, you guys probably have some decent equity there, and your spouse is entitled, if you keep the house, to be bought out or paid 50% of the value of the equity in the home. Now, for a lot of folks, that's a really big nut to get. And most people aren't walking around with that kind of money in a savings account or some other account where they can just create that buyout. This creates the necessity for a lot of people to do a cash out refinance of the home in order to pull enough cash out of the equity of the home to pay off the other spouse so that they are made whole on their half of the equity, which ultimately results in a much higher mortgage payment. Not to mention, in the high interest rate environment that we're in right now when I'm recording this video, you might have people who have a 2 or 3% interest rate on their mortgage that refinance the house in order to keep it in a divorce, and now they're sitting on a 7.5% interest rate, which makes a tremendous difference in what the mortgage payment's going to be. Not to mention the fact that now you are paying a mortgage on a much bigger amount of money because you had to pull equity out of the home to pay off the other spouse. In most cases, fighting over the house is really just a matter of both parties realizing and coming to grips with the fact that neither one of them can really realistically afford to keep the house after the divorce. The problem that I see every day is that a lot of divorce lawyers are not having this talk with their clients early on. Instead, they're fighting and advocating throughout the case only to have this gut level honest conversation with their client toward the end of the process rather than at the beginning. The second thing I'm going to talk about today is the fact that the court is going to require, if you keep the house, for you to take care of a couple necessary items in order for that retention of the house to go through. The biggest and most common thing that really trips up a lot of spouses is the fact that if the mortgage is in both parties' names, then the party keeping the house is going to have to do a refinance on that home in order to remove the other party's name from the mortgage. This is a big problem for a lot of people because a lot of people, by the time their situation has spiraled to the point where they're going through a divorce, their credit has been damaged, their savings has been depleted, and a whole laundry list of other bad circumstances have probably taken place that would impact their ability to qualify and pull off refinancing the remaining mortgage on their house. Not to mention if they have to take part in what I said in step 1, where they have to do a cash out refinance to buy the other party out of their half of the equity. So the fact is, if your mortgage is in both parties' names and you don't think you can qualify for a refinance to remove their name from the mortgage within 3 to 6 months, then fighting over the house may not be worth it. Now, a lot of times we will see a spouse go after significant amounts of spousal support and child support with the goal of increasing their income through alimony in order to qualify for that refinance, or to leverage the other party into just waiving their half of the equity in the home as some sort of lump sum alimony. These can be effective strategies in a lot of cases, and you always want to talk to your lawyer about how it's going to apply to your particular situation. But I have seen people engage in extremely unreasonable amounts of litigation and spend tremendous amounts of money and emotion and resources and stress in the effort to try to keep the house, even when it just didn't make sense. I'm going to tell you from my experience, if I were you, I would not expect any sort of scenario where the other party's lawyer is going to be okay with them signing a marital settlement agreement that allows you to keep the house, but keeps their name on the mortgage. Any lawyer who knows what they're doing is not going to let that happen under any circumstances. The third and final piece of this is, what happens when you've got that really toxic spouse on the other side and they decide, hey, if I can't keep this thing, I don't want you to have it, so I'm just going to burn the whole thing down. Any attorney who's willing to assist their client in anything that could be classified as burning it down in their divorce, in my book, would be shady, and that would be unethical. But what does this consist of? What does burning it down mean? And what do you do about it if it happens? This kind of approach can take many forms, and it can manifest itself in a lot of different ways. So you really got to be on the lookout for this. The most common way that I see this is where a party who has, traditionally paid the mortgage and the homeowner's insurance and the utilities and all that stuff just suddenly stops paying all those bills. That's common in a lot of divorce cases, especially if their spouse starts asking for things like alimony and temporary support and attorney's fees and the whole nine. The good news here is that if there's a pending divorce action in most jurisdictions, your attorney can get in there really fast in front of the court, let the court know what's going on, and the court will usually make expedited or emergency decisions in order to ensure that those bills keep getting paid. But where this really gets dangerous is if no one has filed for divorce yet, you guys know a divorce is imminent, so the court is not involved in your situation at all, and somebody stops paying the mortgage and all the other bills, and the other spouse is hesitating or procrastinating contacting an attorney to file for divorce, that's when it's dangerous. Because these banks really aren't messing around these days. They will initiate foreclosure proceedings lightning fast, and they'll move them through the pipeline as fast as they possibly can. If this is allowed to go on for too long, you could be looking at a worst-case scenario situation where you take something that would have been a very significant asset that the two of you could have divided in your divorce, and it now becomes a liability where it's owned by the bank. It's no longer an asset that you guys can divide, and you may well owe money to the bank based on any shortage that the bank ended up incurring as a part of foreclosing on the house and selling it to another party. I'm not a real estate or foreclosure attorney, so check the rules in your jurisdiction. But if anyone stops paying the bills on the house leading up to the divorce or during the divorce, that is a red alert situation. Another way that we see this, though less common, is where one party will go and take out a home equity line of credit or some other form of a second mortgage on the house. They'll blow that money on all kinds of crazy, insane, stupid things. And then when the divorce finally rolls around, now there's little or no equity or substantially reduced equity in the house for you to get any of. Meanwhile, they may have taken their new significant other on some extravagant vacation to Dubai, or bought an asset and put it in someone else's name, or all kinds of weird stuff that gets really complicated for the lawyers to figure out and untangle once the divorce gets started. Even though this seems like common sense, just be careful, because we hear from folks all the time that right before the divorce was initiated, they signed off on a home equity line of credit and a whole bunch of equity in the home was depleted, and no one knows where the money or the assets were. And then it becomes a litigation marathon for the lawyers to figure out what happened, who did what, and where'd it go, and how to make both sides whole. I want to add here, guys, that this is by no means an exhaustive list. There are so many other aspects to the issue of parties in a divorce fighting over the marital home, how that works, what has to be done, what the tactics and strategies are, and what the bad stuff is that the other side can do to try to hurt you in that case. So Always talk to your own lawyer and your jurisdiction about your specific set of facts. Remember that nothing in this video constitutes legal advice or is an invitation to establish an attorney-client relationship. I'm licensed to practice law in the state of Florida. We operate primarily in Orlando and in the Central Florida area. Don't forget, if this video added some positive value to your situation, hit that thumbs up icon and subscribe to this channel for more. God bless you guys. I'll see you in the next one.